Okay, folks. Well, let's go ahead and get started here. So I thought today we'd do a brief bit on closing meetings, specifically how one can do this consistent with the open meeting law, and some of the traps that folks run into with this. So we're going to be talking about a brief introduction to the open meeting law. When can we close? How do we close? And then I'll be pointing you out to a new resource, which hopefully will help you out. So for those of you who haven't had this conversation with us yet, the open meeting law is it's a law in Minnesota, longstanding. It is pretty harsh on us, but it is at the end of the day rooted in concerns about good government. The basic rule here is that all meetings, including executive sessions, must be open to the public. Now, open to the public in this case does include certain notice procedures. You have to post it in certain cases. You have to mail notices in certain cases. Most of this is contained in Minnesota Statute 13D.01 and Minnesota Statute 13D.04. Now, meeting in this case is undefined by the statute because of course, the legislature would do that. But what it means, as interpreted by our Supreme Court, is this: a meeting is a gathering of a quorum or more of the voting members of the governing body at which members, quote, discuss, decide, or receive information as a group on issues relating to the official business of that governing body. Now, that creates some pretty obvious issues for us, right? Aside from the fact that our quorums are naturally pretty small, most of our members operate on the 3-member board principle. And you don't even have to actually be discussing anything. You can just be receiving information. So theoretically, if 2 supervisors at their grocery store together and somebody comes up to them and starts talking to them about a condition of the road, you are potentially violating open meeting law. So that's one sort of concern. But others are about subject matter, that we are potentially dealing with. What about, security precautions? If we're worried about somebody, kicking the door down and taking, stuff out of the township hall. If we have to interview somebody for a job, that can be problematic. What about the sale price or purchase price of real or personal property? Obviously, if the other party gets to sit in on the process by which you come to your bottom line, it's a little bit hard to protect public money. What about talking to attorneys? And what about potentially issues that are just particularly heated? And I'm worried that I can't have a frank or an open discussion. So these are some of the fairly common questions that we get related to this thing. But there are circumstances under which we do get to close our meetings here. So it's a non-exhaustive list. To determine the asking price of property that we're selling, real or personal, you get to close a meeting for that. Receives briefings or reports related to security, you get to close a meeting for that. Preliminary considerations of allegations or charges against an individual subject to the public body's authority, you get to close a meeting for that, potentially. Attorney-client privilege, that's another one. So there are ways to do this. But once you've gotten into it, so the process is pretty straightforward. So every closed meeting has to begin as an open meeting. So complete with notice, complete with allowing the public to attend. The board must identify the specific reason that it thinks it can close the meeting. And this isn't just as simple as attorney-client privilege or we're talking about security today. You need to state the specific statutory provision that allows you to close it on the record. So this one is a pretty technical and pretty potentially problematic requirement for a lot of our members. And that citation needs to be included in the minutes, because if you get sued on this thing, you're going to need to be able to show the court that you said it, right? Now, once that has been said, all closed meetings with a big asterisk must be electronically recorded and preserved for at least 3 years. Sometimes they have to be preserved for more, but default rule is going to be that 3-year rule. Now, most of the exceptions that we're talking about do require the board to do or say additional things. So this is just sort of the default set of rules, but you're going to want to have in mind the specific provision that you are looking at, and you're going to want to walk through that procedure very carefully. This is the kind of thing that you're going to want to give us a call. You're going to want to read the statute yourself. because it gets technical, and if you screw up the details, you can potentially get in trouble. So talking about a particular example here, say you were considering the sale or purchase of real property. That is one of the things that the board is allowed to close a meeting for. So Minnesota statute 13D.05 subdivision 3. So you start out by opening the meeting, and then before you go through your process, you identify what statute specifically says allows you to close it. And then before holding a closed meeting on these grounds, in addition to the normal requirements, the town has to, quote, identify on the record the particular real property that will be the subject of the closed meeting. So on top of that citation, you're going to want to include like an address, a description, something like that, in order to satisfy the requirements of this particular exception. Then in addition, just to give you a sense of how detailed this stuff can get, so the proceedings have to be tape recorded at the expense of the public body. That is, this is one of those weird little bits where we are told to record it and preserve it twice, once record and once tape record. So theoretically, you're going to want to be doing that through the tape recording process. Now, I don't think a court is going to get real mad if you're using a digital recorder rather than strictly something that's tape, but just so you know, there is that distinction between the language there. So this one recording, this is an example of where you get a special retention rule. The recording must be preserved for 8 years after the date of the meeting. It must be made available to the public once all the property discussed at the meeting has either been purchased, sold, or if you've given up on the transaction. That is, you made the offer, they didn't take it, you're done with this process. So you can keep it, private up until the transaction is more or less concluded. You have to identify it specifically on the tape, so not just on the record, but also audibly on the tape. And then if the tape isn't available, then you're sort of subject to some special provisions here. So theoretically, if somebody, if you're engaging in a longer real estate transaction, something that's going to take, a number of negotiating sessions back and forth, what can happen is you've got this private tape, it's not available to the public yet. And there's this little process in 13D.03 subdivision 3 that the court gets to go through to view it, basically, or to listen to it. So in addition to all those special recording properties, you have to list members and all other persons present at the closed meeting, and that list must be made available to the public after the closed meeting. So even when the audio recording itself isn't available to the public, this list of participants has to be available to the public. And after you're done with all of that, the actual final approval has to happen at an open meeting after the notice period required by statutory governing bodies' internal procedures. And purchase price or sale is public data. And that's going to be a theme that you're potentially going to see if you start looking into this more deeply. The legislature is pretty clear that they want financial information to be made available to the public. The thinking here probably goes something like sunlight is the best disinfectant. So we don't want to make it easy for folks to hide the financial ball, so to speak. So most of these exceptions will allow you to discuss kind of the meat of things, but they will not allow you to hide any financial data. Security is like that. There are other ones like that. One thing that's important to note here is that it is possible for a government entity to screw up both ways. So this is something that you're going to want to be very careful with. Now we have, on the one hand, Unke versus Independent School District number 147, in which a school district, this is something that a township is unlikely to come across, of course, but just so you know, there are these must close provisions. So the school violated open meeting law by disclosing sexual abuse related data at an open meeting. So they got in trouble for not closing the meeting. More common for townships is the situation in Prior Lake versus Matter. And that's a city violating an open meeting law by thinking that they were closing properly under attorney-client privilege when what they were talking about was not close enough to actual legal strategy to count for attorney-client privilege. So this stuff is pretty detail oriented and potentially difficult to kind of wend your way through. We have, for the convenience of our officers, created a new document, TM 8000, in the information library now. If folks are interested in taking a look at that, that kind of has a listing of all of the common exceptions along with the procedures that you go through. So if you're curious about this thing, if you've got something that you think probably counts, this is a good document to take a look at. And then, of course, for those of you who have been longtime viewers, you notice that we got some intro music today. Happened to stumble across some rights-free music, and their condition for letting me use it was to credit them. This is the credit. So, all right, folks, let me stop the share here. All righty. Question that I was asked and I didn't know the answer. Can election judges post stuff on social media about candidates? So the stove is pretty hot here. Public officials do not give up their rights as citizens under the First Amendment. So you certainly can't stop them on their own time. Now, at the actual election, that would be much dodgier. I believe there's a statute that's on point that would forbid, them, kind of canvassing at the polling place itself for obvious reasons. Now, First Amendment jurisprudence has been changing. And so there's a little bit of uncertainty around the enforceability of that statute from my perspective, but I would default towards the statute at this point and say that the polling place is the line. That's the sacred space that they can't be sort of violating. Maddie discussed a similar subject matter at the District 8 meeting, referring to actual commissioner and or employee of the county. Timing would be an issue about when they actually in the employee of the township. That's also true. Election judges are one of those weird things where you're only employed for a pretty specific period of time. So certainly when you're on your own time, First Amendment would I would be very hesitant as a public entity to try to censor somebody around political speech when it's their own private time, frankly. You do have to be, I don't want to say that it's never possible, but this is the kind of thing that you're going to want to have a very solid handle on the law before you move. So if you've got a specific, hypothetical in mind, happy to give me a call. Happy to talk it through after today's presentation. Or call Maddie or Steve if you prefer. But this is the stove is very hot here, and government agencies, government entities, political subdivisions do get in trouble for trying to discipline folks around political speech. Like that's a common fact pattern. Where and what would be the process to find out about new candidates filing to be on the town board? We have 4 new candidates on the ballot. So this one can be a bit tricky if you are trying to discover, who is running. I think ordinarily, if you're talking about a bigger city or a county commissioner, there'll be, websites, there'll be, political events, fundraisers that you can kind of just show up and sort of talk to these people. Townships tend to be a lot more informal. Yeah, it's just the residents asking. I would make a point of directing them to the candidate themselves. So if they've got a Facebook page, if they've got anything like that, send them a letter, give them a call. There isn't really any legal requirement that people campaign. I think that's one of those things that the legislature just sort of assumes that any political candidate is going to do, try to get themselves out there to introduce people. But there isn't like a legal requirement for them to do that exactly. So that can be a little bit weird when you're talking about some of our smaller elections here. All right. Well, do we have any other questions here? All right. Well, thanks for your time and for your attention, folks. Hope it was useful. Hope you guys liked the new resource. and find it useful. In any event, have a good morning and happy September.